Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today, we are going to address a question that arises in the minds of many people again and again. Can a tenant ever become the owner of a house or property? Many times, it is seen that people live in a house on rent for a long time and start thinking they have become the owner. Some get electricity and water bills transferred to their name, while others begin paying property tax and assume they now have ownership rights. But is this assumption correct? What is the legal truth behind it? Today we'll understand this in detail, along with some important Supreme Court and High Court judgments from 2024 and 2025. 1. Tenant versus owner. What's the difference? The biggest difference between a tenant and an owner is that the owner has a legal and registered title of the property, meaning he is the lawful owner under the law. Whereas a tenant only has the right to use the property, that too with the owner's permission and for a specified period, by paying rent. The important point is that a tenant has the right to use the property but cannot call himself the owner, unless there is a valid and written ownership transfer. 2. Can a tenant ever become an owner? The answer is, yes, a tenant can become the owner, but only under very limited and legally accepted circumstances. Mainly there are two ways. A. Transfer of ownership by consent and agreement. 1. Sale deed. If the property is sold to the tenant by mutual consent between the owner and tenant and a registered sale deed is executed, the tenant can become the owner. 2. Gift deed. If the owner gives the property to the tenant without any consideration and the gift is registered, ownership can be transferred. 3. Will. If the owner, in his will, bequeaths the property to the tenant, and the will is legally enforced after the owner's death, the tenant can become the owner. 4. Exchange settlement deed. If the owner transfers the property in exchange for another property or right and a registered deed is executed, ownership can transfer in such cases too. B. Adverse possession. This is a complex and controversial process where a person, without valid ownership, continues to occupy a property openly, continuously, and in opposition to the owner's rights. Over time, he may claim ownership. For private property, 12 years. For government property, 30 years. But this requires several conditions. The possession must be open, continuous, and without legal title. The owner must be aware that someone is occupying his property. The possession must be without the owner's permission. Most importantly, the tenant must have stopped paying rent. In the case of tenants, it is even more difficult because their occupation starts with the owner's permission. Hence, to claim adverse possession, the tenant must prove that later he rejected the owner's authority and the owner was aware of it. 3. What does not create ownership? Many people believe that paying property tax or having utility bills in their name makes them the owner. This is completely incorrect. Law says, having electricity, water, or gas connections in the tenant's name is only for convenience. Paying property tax does not prove ownership unless there's a registered transfer. Long-term stay on rent without valid transfer documents does not grant ownership rights. 4. Major Supreme Court and High Court judgments. 1. Karnataka Board of Wakf v. Government of India, 2004. Supreme Court clearly held that the person claiming adverse possession must prove that the possession was against the owner's rights, open and continuous. 2. Mohan Lal v. Mirza Abdul Gaffar, 1996. The court held that a tenant, who initially occupied the property with permission, can claim adverse possession only if he proves that he rejected the owner's title and the owner was aware of it. 3. Sarup Singh v. Banto, 2005. Here the court said, unless the tenant explicitly notifies the owner that he is now claiming ownership, he cannot benefit from adverse possession. 4. Rajesh Kumar v. State of Haryana, 2024 SC 557. In this recent decision, the Supreme Court clearly stated that just because someone has been a tenant for years and has been paying tax, he does not become the owner. Unless a registered title is transferred, ownership does not arise. 5. Meena Devi v. Jitendra Singh, 2025 DHC 91. Delhi High Court held. Having electricity, water, or gas connection in the tenant's name is only a matter of convenience, it is not proof of ownership. 5. Practical advice for owners and tenants. For owners, always get a registered rent agreement with the tenant. Renew it from time to time. Maintain records of rent receipts and payments. For tenants, if you want to buy the property, get a sale deed or gift deed executed. Adverse possession is a difficult and legally risky route. Don't claim ownership without valid documentation. Conclusion. So friends, becoming an owner from a tenant is legally possible. But only under the following conditions. Either the owner voluntarily and legally transfers ownership, or in rare and clearly proven cases of adverse possession. Avoid misunderstandings, don't be driven by emotion. Claim ownership only through written and registered legal documents. Thank you for watching this video. If you found this information useful, please like, subscribe, and share your views in the comments section. And yes, don't forget to press the bell icon for more such legal insights. I'll see you in the next video. Jai Hind. Jai Bharat.